Okay, so welcome everyone to the final session of our 2 days conference. And this session is titled Memory and the Politics, Rule of Law versus Rule of Government. And of course, as you can see, within this session we'll hear from 3 excellent researchers whom I will invite to present their thesis in a short moment. So we have with us Professor Gary Simpson from the London School of Economics and Political Science. We have Dr. Marina Ban from the University of Copenhagen. And we have Associate Professor Karis Papaharalambous from the University of Cyprus and Goethe University. And as the first speaker, I would like to invite here Professor Gary Simpson, who is a professor of international law at the London School of Economics and Political Science. And actually, his latest book, The Sentimental Life of International Law, Literature, Language, and Longing in Global Politics, is being published this month by Oxford University Press. So, of course, I am encouraging you all to get acquainted with it. And currently, he is also working on another publication called War, International Law. So we can only wait for the results. So Professor Simpson will share with us today his insights on the topic Unprecedented International Law, History, and the Production of Battles. Professor Simpson, please.
Well, thank you, Professor Radwan. Thank you for the invitation. And Sonia, thanks for looking after me in the last day and organizing the trip and so on. So it's great to be here, and I have been very inspired, in fact, by the conversations. I've been busy rewriting my paper, actually, in response to them. So I thought I'd take a slightly different tack. Instead of giving the paper I was going to give, I'll at least spend the first half trying to respond to some of the things that have emerged in the last little while. I really want to start with the paper, the paper that immediately followed me, your paper, with that marvelous image of the 2 Czech women and the large statue, because it responds so directly to the sorts of themes I take up in the book that's just been published. And I think perhaps one way to respond to historical memory and what Nietzsche would have called monumentalism is to take a kind of anti-monumentalist view of it. And it struck me that these 2 women in that picture were performing precisely that form of anti-monumentalism. So instead of, as I was trying to say in my sort of ill-conceived question to you, instead of destroying monuments or celebrating them, one adopts a sort of sardonic attitude towards them. And it seems to me that there are better prospects for reconciliation with that kind of move. Okay, so the 3 subjects I want to speak about are amnesia, authorship, and precedent. So first of all, I want to talk about international law's memory culture. Memory culture was a word that came up today, and I want to talk about it through the concept of amnesia and the apparent relationship between forgetting and memory. And the thesis, to use your term, of this part of the paper is that memorializing often produces a form of forgetfulness. But I might get to that later. So, I mean, international law or international war crimes law sort of begins with a form of forgetting or amnesia or a demand to forget. If we think about the origins of international law, for example, at the Peace of Westphalia back in 1648, after the great religious wars in Europe, the European states came together at Münster and Osnabrück and declared that they were going to set their differences aside and that they were going to forget any of the violent acts committed during these troubles. So international law begins with a sort of disavowal of memory and a disavowal of the prospect of trying one's enemies. In other words, it begins with an act of forgetting that's also the inauguration of a kind of sovereignty in international relations. And we see this all through the history of international law right up until the 20th century. We see it, for example, at the Congress of Vienna and the treatment of Napoleon and the refusal to contemplate a trial for Napoleon, a sort of historical reckoning. Instead, we have two forms of exile. And if you pick up, say, Henry Kissinger's book on the history of diplomacy over the past 300 years, he just doesn't mention war crimes trials. He's not interested in memorializing. He's not interested in memory. He's interested in building an international system around various ideas related to the balance of power. And even in contemporary international law, so we might argue that international law, and in fact diplomacy, has taken a turn towards history and towards memory, but in contemporary international legal diplomacy, let's call it, there is a lot of forgetting. You spoke this morning about the European Court of Human Rights and the idea that it forgets everything that happened prior to 1950. And we see this scattered through the enterprise of human rights and international criminal law. So these disciplines dedicated to remembering are procedurally, or have a procedural tendency to forget. You see it in the International Criminal Court's prospective jurisdiction over war crimes. You see it in the way in which the International Criminal Tribunal for the former Yugoslavia has jurisdiction over war crimes, but only those committed after January the 1st, 1991. Or in the Australian war crimes legislation of the late 1980s, which purports to take universal jurisdiction over war crimes, to remember war crimes in a universalist mode, but restricts the jurisdiction of the court to a period between 1939 and 1945 in Europe. Or the way in which the trial of Klaus Barbie in Lyon restricts the meaning of crimes against humanity precisely to exclude the sorts of crimes the French state might have committed in Algeria during the 1940s and 50s. So international law is poised, I think, between memory and forgetting, and I think we have to take due account of the forgetting in order to understand better its self-advertised virtues of memorializing. So that if we look back finally, and this is the last thing I want to say about amnesia, if we look back finally to the Nuremberg war crimes trials, we can see that the trial was as much about forgetting certain crimes as remembering others. The trial is remembered as the remembrance of the Holocaust, though the Holocaust was far from central to the judges in the Nuremberg war crimes trials. It's remembered as a moment of remembrance, but in fact there's a great deal of forgetting done in the trial. The trial forgets, for example, the bombing of Dresden. The trial in Tokyo forgets Hiroshima and Nagasaki. So each of these monuments to international criminal law is a strange mixture of memory and forgetting. Okay, let me say something then more general about history and international criminal law. And there are sort of two or three ways into this. One is to think about the history of international criminal law itself. That's not something I really want to do today. The second is to think about the way international criminal courts write history. So I call that the question of authorship. And the third is the way in which international criminal courts use history. And I want to deal with that under the heading of precedent. And I'll just preface these comments by saying there's a lot of anxiety or nervousness expressed around war crimes trials when people come to observe them, especially for the first time. Think about Hannah Arendt's agonizing over the Eichmann trial in 1961. Think about the historical controversies that swirled around the Milosevic trial in the mid-2000s. So let me begin with authorship. In 1919, when international criminal law began, in my view, the peacemakers at Versailles established a commission with a rather unusual name. They called it the Commission on the Responsibility of the Authors of the War. The Commission on the Responsibility of the Authors of the War. And the first thing this commission did was to reject the title it was given. The commission found that there had indeed been a dark conspiracy on the part of the German state and its allies, but that this wasn't authorship, that no one single individual in particular had authored the war. In other words, while it was possible to prosecute individuals for war crimes or crimes against humanity, or what we might think of now as acts of genocide, though the word wasn't really around at that time, it wasn't possible to prosecute individuals for the crime of aggression. War couldn't be understood in those highly individualistic ways. It seems clear to me that since that point, at least in 1919, international criminal law has gone in the opposite direction, and it's adopted, embraced in fact, the idea that history is in some way authored. History is authored not just by states, but by individuals. And that wars, far from having the sort of murky origins we attribute to the Great War, for example, are authored by single malevolent individuals. Milosevic, Göring, Tojo, and so on and so forth. Okay, let me turn to unprecedentedness, because that was the actual subject of my paper. James White once told us that the lawyer is a user of words, but like all such people, he must use them in a world of unexpressed and inexpressible experience. What happens when international legal languages begin to articulate what had long been thought to be inexpressible or unprecedented experience in history? So here, international criminal law, or war crimes trials, or the history produced by war crimes trials, and I'm borrowing from Peter Gable here, can be understood as a form of alienated legal thought, a sort of leveling down. In its judicial doctrinal life, the establishment of an international criminal law has necessitated a sometimes half-hearted search for a history of largely inadequate precedents in the context of the punishment of acts that are also said to be unprecedented. Think about the way the Holocaust is understood as unprecedented, or absent from, or acts that are absent from history. And in the shadow of a suspicion that the criminalization of such acts themselves are unprecedented. When German artists scanned history for monumental forms, in other words, precedents that could be revived or recuperated in the attempt to memorialize the Holocaust, they experienced past monuments as perpetually disappointing, incommensurable, or overtaxed. There was something wrong about the monuments, or the style of monuments that had existed prior to 1945, and they weren't to be imitated by German sculptors and architects of the immediate post-war era. So they embraced the form of anti-monumentalism. In a similar vein, the idea of international criminal law, indeed law itself, as somehow an anticlimactic response to atrocity, goes back at least to Karl Jaspers in his correspondence with Arendt, and the idea that the Holocaust exploded the limits of the law. So what might it mean then to build precedent on the unprecedented, or to ground the unprecedented on precedent? And here I think international law can be understood as a discipline performing itself in the style of what I call bathos, or anticlimax, or incommensurability. The combination of sublime violence on one side and inadequate law or banal evil on the other is a signature of commentary on war crimes trials. So we've got the Eichmann trial, where Eichmann's shallow wrongdoing provokes in Arendt a sense that the whole proceeding is indescribably inferior or worthless. Indeed, in her New Yorker essays, Arendt contrasts Eichmann's thoughtlessness and lack of depth with the Baroque evil of a Richard II, or the imaginative, cunning will to power and destruction of someone like Iago. Eichmann is the very embodiment, not just of banality, but of bathos. He enters the district court of Jerusalem with the audience anxiously awaiting the monster's entrance. Instead, everyone's next-door neighbor arrives. Arendt is confronted with a ghost who minute by minute fades in substance. He's an inadequate standby for history. Eichmann's personification of bathos is given a spectral twist in Arendt's writing. He becomes more and more ghostly, his presence increasingly anticlimactic. The effort to implicate him in the cold-blooded murder of a Hungarian Jewish boy is the last gasp of this effort. So here we have historical memory and law sort of eyeing each other very, very uneasily. According to Arendt, the precedents for Eichmann's crimes could be found neither in existing international law nor in law itself. So the Holocaust was for people like Arendt and Jaspers a sort of event that exploded the juridical surroundings and demanded new law. But both at Nuremberg and in the Eichmann trial, the respective courts initiated a search for precedents. They initiated a search for history, a history that law needs for its authority. But it was a history that wasn't there. At Nuremberg, genocide is collapsed into wartime excess or is wrapped up into crimes against peace. So the tribunal is concerned to pluck precedents from history in order to support the application of crimes against humanity or the crime of aggression to the defeated Nazis. The precedents themselves seem measly and strained, inadequate to the task. The abduction of Eichmann, for example, is set alongside some US Supreme Court decisions in which suspects are snatched from Illinois by troopers based in Michigan. The District Court of Jerusalem conjures an image of Adolf Eichmann as a pirate, a sort of Jolly Roger who happened to be placed in charge of a Europe-wide extermination program. In the end, Arendt remarks that the world's press had not gathered in Jerusalem to see Bluebeard on trial. This all begins in 1919, this mismatch between history and law, with this commission on the responsibility of the authors of the war, offering up a startling list of German iniquities. These surely are the most horrible, and remember this is 1919, these surely are the most horrible, indeed unprecedented violations that human beings could commit. But this list of so-called German atrocities is odd. The atrocities resemble a musical hall joke, where grave offense is punctuated by trivial violation, as if man's inhumanity to man could be captured in the failure of an occupying authority to deliver the mail. But then maybe the judicialization of war itself is an exercise in this falling off or bathos. So we have the war poet Siegfried Sassoon's butchered, frantic gestures of the dead becoming, in the eyes of the law, serious violations of the laws of war. One senses very clearly here a sort of dropping away. But the 1919 list, and I'm sort of coming to a conclusion now, timekeeper, but the 1919 list has a strangely proleptic quality as well. What is being described in this list in 1919 is not unprecedented atrocity, but yet to be witnessed destruction. The atrocities, after all, were obviously inflated, sometimes fabricated. Indeed, the bayoneted Belgian babies of occupation mythology have become a byword for a certain sort of war propaganda. The commission, busy documenting German crimes, actually describes a set of atrocities that were yet to be brought into existence as either crimes or atrocities. That would take place in the 1940s. There was no evidence for the atrocities reported by the Allies of maimed Belgian children, their hands hacked off by German soldiers. Elsewhere, though, there was plenty of evidence. The reference, a Freudian one perhaps, and we're in the city of Freud, was to the policy of documenting killings in the rubber region of the Congo by the Belgian state. This was, of course, forgotten, or it was remembered as a form of humanitarianism. This goes back to my point about the way in which compulsive memorializing is also a form of forgetting. And the structure of international criminal law's history, too, is constructed around this bathos. The proposed trial of the century at Versailles becomes a smattering of legal proceedings in Leipzig. In the late 20th century, we see a history of little old Nazis, beloved by their grandchildren, staggering to the dock to account for one of the greatest genocides in history. The ICC, beginning in a flush of pomp, ceremony, and the promise of transformative justice, ends up with relatively minor figures like Lubanga in jail for having deployed child soldiers. Meanwhile, the persistent deployments of phrases such as crimes against humanity or genocide or gross violations of human rights sometimes transforms juridical innovation into slogans with the life drained from them. History and law in a perpetual mismatch.
Professor, thank you very much. And now let me introduce to you Dr. Marina Ban, who earned doctorate from the University of Amsterdam last year in 2020. And Marina's thesis, The Legal Governance of Historical Memory and the Rule of Law, examined selected states' treatment of their past and evaluated how governmental control over historical memory via legal measures affects the rule of law. And Dr. Ban is now a postdoctoral researcher in the ERC-funded project Imagine at ICORD's University of Copenhagen, working on European and Hungarian constitutional law. And today we will hear about legal governance of historical memory and the rule of law. Dr. Ban, please.
Yes, thank you for the introduction and also the invitation. And yeah, I thought that the bio was going to be for the website because it kind of spoils the entire presentation just because I'm talking about my PhD research, which I'm now trying to continue and hopefully turn into a book sometime in the near future. That is a we will see kind of situation. But anyway, so this presentation is actually about the interaction between what are called memory laws, so all kinds of legal measures that enshrine different historical interpretations by states, and the rule of law. And specifically, it is about how governmental control over these memory laws can affect the rule of law, and it can cause various problems. Because I think that in the previous panels we have heard of instances where, for example, governments have used certain laws to disseminate narratives that are at least factually questionable, if not downright inaccurate. I mean, we have heard about the Hungarian constitution, and I will keep going back to Hungary as an example because that's a context that I'm quite intimately familiar with. And then also on the practical side, these laws can also be used to punitively punish certain historians or journalists whose views may not align with what is considered appropriate by certain governments. And actually, I kind of got to this rule of law research in a very interesting way because the sort of traditional lens to look at memory laws in general have been from the perspective of fundamental rights. So this traditional analysis of, for example, putting restrictions on speech relating to historical events can then, how is it compatible with the right to freedom of expression? But I arrived at this rule of law perspective because I kept seeing, and particularly in the Hungarian situation, there is a tendency to put next together the general deterioration of the rule of law in the state, and then also these observations about, yes, how the new Hungarian constitution is full of these historical narratives and they are kind of controversial. And these things are put next to each other, but I thought that it would be perhaps a good idea to try to figure out some connection or interaction between them. And when I talk about these memory laws and the legal governance of historical memory, it actually works on three levels for me. Because there is a constitutional level, as I've mentioned, the inclusion of historical narratives in different constitutional documents. There is also a statutory level, which is a more traditional, just general laws, for example, the classic laws of prohibitions of genocide denialism. And there's also a third aspect that I was looking at is what I call the ostensible level or the ostensibly legal level, which what I meant by that is the context around the laws and especially the political speech that leads to them, because again, to keep coming back to Hungary, there is a wonderful thread that can be just pulled from introducing a certain issue into the public by some sort of interviews with government officials and then thematizing it for weeks and weeks and month, and then suddenly there's a law and there's a constitutional amendment. So that's why I thought that it was important to also look at this area of the memory laws. And I actually had a little bit of a hypothesis, which kind of came true, like at least halfway, about the extent to which the rule of law can be affected by these memory laws. And I sort of hypothesized that it depends on the approach or the motive that the government possesses towards its own history. Because it can either possess what is called a self-inculpatory approach, which tends to more embrace accountability and be more self-reflexive in a way, or it can be a sort of self-exculpatory approach, which tends to be more selective and more arbitrary, and also focus more on glorification rather than self-reflection. And to bring the rule of law into the discussion, I found this to be an incredibly elusive and difficult concept to break down because there's so many conceptions and so many different ideas about it. And I sort of tried to synthesize it in my own conception and try to find certain elements, and that's not an exhaustive or comprehensive list by any means, but try to find the elements which are important to this discussion. And there were four that I found. The first one was about certainty and predictability in terms of how these memory laws are foreseeable and the reasonable expectations and consequences that can be brought by them. The second is equality before the law, which is, in my interpretation, was about the treatment of particularly minorities on a historical basis in some memory laws. And then I looked at the role of the judiciary in terms of how judges are involved in the shaping and interpretation of the laws and where this might lead. And then I also brought in this more traditional fundamental rights lens to look a little bit about the traditional questions of memory laws affecting freedom of speech or freedom of assembly. And then I actually took two examples, one country from a more stable general rule of law situation and one from a more, currently, unfortunately, deteriorating rule of law situation. And in my more stable rule of law situation example, which was France, I found, and the other one was Hungary, which is the more deteriorating part of the research, and I found some very interesting differences and similarities between them. But in the French case, for example, what was interesting is that the role of historians and civil society and the engagement of sort of the non-political elements of society made a lot of difference in terms of mitigating the sort of harmful impact that memory loss could have, because a lot of these law conceptions have not even come to fruition because they were stopped before they could even exist. However, that doesn't mean that the French situation was all sunshine and roses, because France has a quite thorough tradition of trying to conceptualize and introduce different bills on genocide denialism, and these tend to be, unfortunately, quite arbitrary. And here I'm not talking about the traditional Holocaust denial bills, but there are some other genocide denial prohibitions which tend to be quite arbitrary. And there's also a very unfortunate, quite nationalistic streak that comes out in the French example, for example, with regards to the shaping of citizenship, because it's quite forcefully expected to adhere to what are called French values, which are then connected to a historical basis when awarding citizenship to people. And then also what I found is that there have been examples of French memory laws which have given very extensive power to judges to not only interpret these laws themselves, but also to, in a way, engage with historical events themselves and define them, despite being judges and not actual historical researchers. In contrast with the Hungarian case, the situation was a little bit different because in the French case, the more the creation of memory laws remained sort of on a statutory level, whereas in Hungary it's very much have been included in the constitution, and it's clearly visible that it trickles down, and it's not just about the preamble, but are actually actual historical concepts in the Constitution, which now the Constitutional Court uses in a most mind-blowing way sometimes. And then also what's unfortunate is that memory laws in Hungary tend to be quite arbitrarily formulated because they are often tailored to specific political situations, and even though they might be prima facie like laws that could be reasonable, but when looking at the political context around them and the way they become quite arbitrary and completely unpredictable. And there's also a very interesting streak of in Hungarian memory laws on how it treats minorities, because, for example, there is a law in Hungary where which differentiates on a historical basis between different minorities, and this is how it assigns a degree of protection to them. So it's quite, well, I can probably venture perhaps a little bit discriminatory in this manner. And then what's also unfortunate in the Hungarian case is that since the judiciary is unfortunately not very independent at the moment. And I've mentioned that the way the Constitutional Court interprets historical concepts are very, very ad hoc and quite interesting in some cases. And then what comes out of these two cases is that while the French case is by no means perfect, but it tends to lean more towards this self-inculpatory approach. I mean, not in every situation, of course, but it tends to lean towards that. Whereas in Hungary, it does seem there is a very strong governmental need to control the past in a very self-exculpatory and glorifying manner. And just to conclude on why I think it's worth to do this kind of analysis is because these approaches, they do make a difference because there is a difference between the rule of law situation in France and Hungary. And then secondly, I think that this kind of rule of law analysis kind of shows a tipping point from the legal governance of memory to what I call the legal misgovernance of memory. Because, I mean, I don't think that it's possible for a state or a government not to engage with its own past and to not make memory laws, so that just wouldn't make sense to just eliminate all memory laws altogether. However, there is a point which I think France has not crossed, although there are some worrying tendencies, but Hungary has crossed to this legal misgovernance of memory where there is very expansive governmental self-exculpatory control over memory laws that results in some very, very harmful practices. And I think that in these terms, the legal governance of historical memory is actually an area where the deterioration of the rule of law can be traced in Hungary, because there is a process where this can be detected. Okay. Thank you very much, I think. Yeah.
Dr. Ban, thank you very much for your presentation. And actually, we came to the final presentation, not only of this panel, but of the entire conference. So, Professor, don't feel pressured at all. But let me then introduce, we have with us Associate Professor Karis Papaharalombous, who is an Associate Professor in Criminal Law and Jurisprudence at Law Department at the University of Cyprus. He is also a doctor in criminal law and law theory at the Goethe University in the Frankfurt am Main in Germany. And his main field of scientific interest includes complicity theories, international criminal law, criminal policy, critical legal studies, and postmodern thinking and law ontology. And today he will tell us a little bit more about criminalizing assaults on memory between national mythology and post-truth. Professor, please.
Well, thank you very much, Sonia. Personally, I thank you very much and the organizers for the kind invitation. I think it's a very good meeting here. I think it's a good event on these crucial issues. So, well, criminalizing assaults on memory between mythology, national mythology and post-truth. Okay, safeguarding human dignity through protection of historical truth without succumbing to over-criminalization is a crucial dilemma for a modern criminal law focused on vulnerability, that is a law which rather protects rights than traditionally punishes a perpetrator. Some criminal laws punish also revisionism beyond negationism. The legislator makes therefore respective laws wide, punishing also such conduct like the downplaying, the approval, or the contestation of crucial facts. Thus, denial is surpassed, and legislators try to compensate for this through requiring elements such as the public display of the behavior or the endangerment of public peace, techniques very much needed, especially where the incrimination covers collective crimes other than the Holocaust. Based on the difficulty of striking the right balance here, criminal law has been accused of offering a rather improper site for the manifestation of historical truth. It is inflexible, it is said, whereas the formation of historical truth is dynamic, or the truth itself may be elusive. It is symbolically strong, but it is nonetheless imposing one interpretation of facts as the truth, promoting through these ideologies vested merely in legal terms. It is thus a vehicle of sanctioning pure immorality despite the secularism of our political edifice, and so of installing a criminal law of the doer, of the perpetrator, who is considered as an enemy, instead of following the traditional criminal law path of the criminal law of the deed. All these characteristics amount to the danger, so the argument goes, that we usher into a state of illiberal and intolerant authoritarianism. What is offered instead is the recourse to public opinion building through policies of remembrance and commemoration. As to the legal dimension of the subject, the alternative is mostly deliberative techniques of imputation and expiation, and the usual label is Truth and Reconciliation Commissions. The argument that a truth commission might be favorable compared to a criminal trial because it lets truth be deployed beyond forensic coercions, and so a certain law's injustice could be tolerated, cannot hold, I think. Criminal trials presuppose that the truth has been found out in the first place. That is, the criminal judge applies the correspondence theory of truth. Insofar, there is no necessary antinomy between justice and truth. But regardless of the fact that truth is not so easily accessible as correspondence theorists would have it, that is, of the fact that epistemic truth is not identical with the forensic one, or of the fact that the epistemic truth is deeply imbued with deontic and value-laden elements, the crucial point is rather something other than truth, namely the stimulation of confession and repentance, which a truth commission furthers, whereas a criminal trial inhibits. As it is correctly said, this is not the case, though. If confession is offered by the commissioner benefits in return, then there is ground to assume a fake confession and a lack of genuine repentance, whereas a criminal trial might cause, and in any case not inhibit, a true confession or an authentic repentance, so far as then the accused would rather want to be punished than seek for forgiveness. As the Argentinian example shows, truth has begun to be displayed and repentance expressed in a manner more preferable than the seeking of truth in the South African Commission. Justice has been served and truth uncovered without the and the traumatizing distortion of it requires punishment. From a utilitarian, consequentialist viewpoint, is that the vehicles of granting peace at the cost of justice, that is, statutes of limitation, amnesties and mercies, cannot bear the same value as they did before this normative rupture. Clemency is therefore not the appropriate means to handle crimes of such type, and the insult contained in the distortion of historical truth amounts to this type of crime inasmuch as it regenerates and intensifies the trauma of the victims of past. It is exactly this link between atrocities perpetrated in the past and the keeping alive of the respect to the victims which constitutes the very meaning of memory in the memory laws. Oblivion meant that then making the trauma more acute meant underestimation of the victims themselves. In an epoch where in criminal law their role in general is enhanced, of the victims I mean. The judge is called therefore to preserve memory beyond compromise and utilitarian emphasis on social pacification. Otherwise, the sole alternative would be that justice is vindicated through the public itself, which is a very dangerous alternative indeed. Concerning the work of legislator and judge, more specifically, to proceed, I think, in a totalizing and comprehensive manner, so that no loopholes in criminal law protection are left. Along these lines, we have to admit that historical revisionism is a pre-stage of genuine denialism, despite the need, I know, to differentiate between them in the name of proportionality. Japan's dealing with the massacre against Koreans and Chinese residents after the earthquake in Tokyo and Yokohama back in the 1923 is illustrative of this grey zone. From the omission of commemoration to lobbyist activities by far-right organizations to indoctrination attempts through the use of the academia, a history war has been unfolded which, unless the law helps, in Japan now, might distort memories which should not be left unremembered. A crucial question is, of course, and apart from the Japanese case, what has to be done if the insult on memory has its sources in the state itself? A question urging us to think further towards the eventual need of more radically universalizing the incrimination of denialism. One could say that there is still more. Punishment of international collective crimes relates to the Roman damnatio memoriae, so far as with the indictment also a message is delivered that historical facts constituting shame are to be spoken of as shameful acts only and not otherwise. Consider Nazism as issue at stake in Germany. It cannot be part of the legal political strife, expressis verbis, because of its damnation. Any discussion which does not conform to the total withdrawal of legitimacy of this murderous phenomenon is ex ante not acceptable. More generally, damnation of past evil amounts to deprivation of authority of the damned, the dismantling of considering the damned as heroes, the total condemnation of their respective deeds. Protecting historical truth, therefore, uncovers the expressive function of the criminal law, its disapprobative message, the facts that punishment is a speech act, causing results in the societal psyche apart from being a means of impacting on factual states of affairs. If this function of the criminal courts trying international collective crimes is their main aim, whereas domestic courts might recur to a traditionally established and well-functioning societal routine, then they play a politically constitutive role in the international criminal courts. They create, as Blake sees things, for instance, a new political community instead of applying old good laws. If this is so, and if we are inclined to normatively generalize, then one might evaluate significantly differently between legal political edifices. Blake puts Germany in contradistinction to Japan, for instance, saying that the latter is appalling in letting things be said and justified that elsewhere would produce outrage. Phenomena like the comfort women, the rape of Nanking, the lethal experiments of the Unit 731, etc. And this is so exactly due to the fact of the lack of normative transformation of Japan through criminal law, to the weakness of Tokyo trials as to the role in reconstituting the law political edifice of the country, which means, further, that a warlike situation is alive when criminal courts condemn collective crimes in a spirit similar to, for instance, the harshness of the Morgenthau Plan, which, aiming at mass executions of Nazis and the purposeful devastation of the country, could, along these lines, be seen under a rather morally and legally sympathetic light. An intricate subject is the interconnection between remembrance of the past atrocities and involuntary furtherance through incrimination of the latter's distortion of particular ethnic identities, a furtherance eventually threatening the integrity of the Republic, especially in countries Mrs. Barney has mentioned this before, where the popular ethnic unity is a historical heritage of immense normative importance. The most eloquent respective case is that of France, of course. The Taubira law of 2001, in combination with the French Penal Code, has incriminated slave trade in French colonies as a crime against humanity. In the Grenouillot case, which is finally withdrawn in 2006, a claim has been brought against the historian who denied that slave trade was genocidal. Discussion turned to litigation, contest turned to crime. To the conflict with the Republican spirit might be added another conflict, this of colonialism's victims with the victims of modern genocides like the Jews, as long as the sufferings of the latter do suit the legal characterization of genocide or crimes against humanity, whereas the sufferings of the former do not, unless one is willing to proceed to a kind of unacceptable historical anachronism. If this activism for memory preservation supersedes tolerance claims and becomes a real movement, then the conflict becomes acuter. If also the memories of the colonizers themselves might be also claimed. This has been the case in Algeria. Descendants of the French-friendly parts of population in Algeria raised such claims, signaling the decomposing effects of vindicating rights due to victimhood as such. The French case illuminates the fact that victimhood is a particularity which might be vested in legal terms, and from the viewpoint of human rights and a criminal law which preserves them should be so vested, although its singular nature cannot be properly dealt with within law's universalistic language. But I know this is a great issue. So let us summarize. There is historical truth. Respect to this truth can be coerced through criminal law as long as otherwise we would tolerate the duration of trauma and suffering. Memory hurts. Further, criminal law has to be maximal, leaving no loopholes of protection and requiring proportionate but austere sanctions. The dilemma between legalizing negationism and downplaying the singularity of the events, whereby the Holocaust is the most eloquent example, cannot be dealt with otherwise than through recourse to universalizing provisions, which must be kept always open, of course, to proper future adjustments. One problem remains, and with this I conclude. What if one does not accept the correspondence theory of truth, which is, as we previously said, controversial? I think we have to distinguish two things. The constitution of truth based on a fundament whatsoever, on the one hand, this fundament being either correspondence or consent, that is, empiricism versus Habermas, and post-truth on the other hand. The latter denies entirely the state of truth. Even lying and deceiving implies still that there is truth, otherwise they were themselves useless. Further, the extinction of the factual and post-truth is not the same with overemphasizing contingency, as postmodern thinkers love to do. There is still a difference between a contingent environment or the fluidity of time which allow us to approach truth only in a perspectival manner on the one hand, and the total abolition of truth, through making beliefs or emotive states absolute on the other. It is thus, I think, clear that the grounds for accepting truth as an interest protected by law remain still sufficient. Thank you so much for your patience.
Okay, and I think with this statement we can begin our final discussion of the conference. So let me direct the audience. Does anyone have a question to our speakers, maybe? Because I will for sure have, but... Okay, so I would like to ask a question, one for Dr. Ban and one for Professor Simpson, actually. And Dr. Ban, you've mentioned these three levels, the constitutional one, the statutory level, the level of the statutory law, so to say, and the non-descriptive one about this political speech, political narration about, regarding the memory laws. And you also gave two examples of the two countries, Hungary and France, where in France you said that more of the statutory level is maybe visible or plays the main role. And in the Hungary, it will be the constitutional law level. And actually, what I believed, like the most heard one probably will be the last level, this level of the whole narrative surrounding the memory laws. So if you were to, I don't know, because if you were maybe to elaborate on this or comment on this, actually regarding these levels and also given examples, maybe you have some also examples from other countries. How do you feel they unravel when it comes to the importance to the whole discussion? Which is the most powerful one? Like, is it more powerful to have it, to have the case of memory laws already grounded in the constitution of the given country, or on the contrary, maybe the narrative, the strong political narrative surrounding the issue, is something that actually impacts the countries in the mostly? So this will be my question for you. And for you, Professor Simpson, I don't know if it's going to be a question or maybe sort of question commentary to the first part of your lecture. You've mentioned this forgetfulness. as an essential part actually of the whole memory narrative. And I can only agree and also add to this, because I believe that the whole historical policy that is actually happening is more focused actually on the forgetting than on memorying, because we can, we can state that actually that some memory laws, some policies are trying to accentuate some chosen political events, but I believe it is more about maybe hiding the ones that should not gather too much attention, and therefore the ones that are supposed to be remembered is actually just the ones that are not supposed to be forgotten. So I would say that forgetting is even more essential part when it comes to the historical policies than the part of remembering. Just my commentary, and how would you address to this, but I think we will start with you, Marina.
Okay. Yeah, and Marina is fine. Like, my title makes me very uncomfortable because I never use it. Yeah. No, anyway, but thank you for your question, because yeah, it's really interesting, because the way I see it is that the sort of the connection between these three levels, it's kind of circular and also interactive, because it's all, I mean, the narrative is important in the sense that, like, I mean, I'm gonna remain with the Hungarian example because that's what I know best, but like everything there starts from some political narrative. But in terms of the strength, I mean, it has like particular strength. I mean, the narrative receives particular strength once it makes its way into the constitution, which actually in other countries happens very rarely, but in Hungary it can happen very, very easily, because the government has such a majority that they can put the constitution whatever they want, because nobody will be able to really oppose it. So, but it is a circular process, so it's usually introduced on the narrative level to thematize to kind of like condition the public that this issue is there, and then put out the point of view that is necessary to then put it into either a law or a constitutional amendment. And yeah, if it's a constitutional amendment, then it becomes kind of a tool also for the Constitutional Court to engage with. And what happens there is that now the Constitutional Court takes on all of these historical concepts and interprets them in the weirdest way possible, which then again affects the people for whom the narrative has been created. So it's like this very strange circular interactive process between these three levels. And actually it's kind of interesting, because in the sort of traditional examination of memory laws, it was the statutory level which was most noticeable, because those were the laws that have existed. And in terms of these sort of constitutional analysis, and also the sort of narrative-based point of view came a little bit later, when I think it's becoming more and more obvious that this interaction between law and history is much more expansive than I think it has previously been considered. So yeah, I think I finish here.
It was just a comment, but I'll comment back. I think the acts of remembrance, official memorializations, just have to be understood as political acts. I don't mean in the sense that they should be discredited as such. I just mean that they should be understood as acts in which there are winners and losers. Some people want to remember certain histories, other people want to remember other histories. And if you choose to remember something officially, it's not so much that you're actively forgetting something, it's just that something will be obscured, something will sit in the shadows of this monument, whether it's a war crimes trial or a physical monument. And a couple of examples I would give of that process are the US Declaration of Independence and the Nuremberg war crimes trials. So if you look at the US Declaration of Independence, it seems to be about the self-determination of these 13 nations becoming a United States. But in the interstices of the document is clearly the sort of submersion of indigenous claims to self-determination as part of that political moment. So that's what's been obscured there. At Nuremberg, it's clear that while crimes against humanity, war crimes to a lesser extent, the crime of aggression are being elevated to a certain position in international law for the first time, and maybe some acts are being criminalized for the first time, it's also true that one can make the argument that the Nuremberg trial was saying that between 1939 and 1945, bombing undefended cities from the air was lawful under international law, and perhaps lawful in that period for the only time in international legal history. It probably wasn't lawful before then. One can certainly interpret the Hague Conventions to be making that illegal, and it probably wasn't unlawful after the Geneva Conventions of 1949. So that's the strange sort of perverse effect of an act of memorialization. That's why I remembered the various memorials produced by these German anti-memorialists. I think there was a memorial to Jewish children in Hamburg that actually disappeared, slowly disappeared into the ground. Initially it was an obelisk, and every year it sunk into the ground deliberately, it was planned that way, by half a meter until it wasn't there anymore. And I think what the memorial is doing there is trying to get us to think about how we remember, how forgetting happens, and how previous acts of remembrance might have been rather muscular and nationalistic in comparison to this sort of irreverent act of memorialization.
Thank you so much. And do we have any other questions from the audience? Okay, so I actually believe that concludes not only this session, but the 2 days of our Assassins of Memory conference. Of course, I would like to thank not only all the speakers, all the guests, but everyone who actually participating in organizing this conference. I'm really satisfied that we get to organize it, even if those times are maybe not so pleasant to meet in person anymore, but still we managed to partially do it. And thank you once more for all your inputs. I will of course contact you later, because as I've mentioned in probably the first message that you all received from me, this conference is actually a part of the larger project of the Law and Memory project that aims to actually finalize both conferences, the last year and this one, in the post-conference publication that maybe will share some lights into the issue of memory loss. And I think Professor Radwan will like to say a couple of ending words to this event. And just to make you remember, please remember that of course you are all invited for a dinner. I think because we've ended a little bit late, then maybe we can postpone the dinner for 6:30. So just, to give you this 30 minutes also time extra to relax and maybe think about the discussion during the dinner being a little bit less formal. So once more, thank you very much.
Well, I didn't plan any specific thank you speech or goodbye speech, because we still have a chance to talk a little bit informally during the dinner that we are just rescheduling half an hour later, because you are 1 hour beyond the time. So we'll hopefully we'll be able to continue. But what we have seen, certainly different experiences and different angles, different efforts. And as when I started this conference, this day, the second day of the conference, I don't know whether we should be happy or not happy that so many people choose this topic as the topic of the research, because it is clearly on the rise. We've seen evidence from many countries that handling history with legal tools is on the rise, And maybe one of the explanations is, well, traditionally, nation building was about creating narratives that everybody could feel to be a part of. And well, self-portraits is an important, self-portrait of a nation is an important narrative, is an important story about a nation. Today, what we see increasingly is coming up with different stories about the nation as something that not necessarily appeals to everyone to feel a part of a nation. Rather, it is used to appeal to groups of voters as one of the competing self-portrayal of the nation. And we see how is it used for internal politics, whereas sometimes damage is being done or some externalities are being created at the very international level. So we see clearly this overlap of domestic politics, legislation, and international affairs. And we see how it is instrumentalized in many countries, and I think some of the, sadly so, examples that the world has seen, not just in Poland, was this repeated struggle between Poland and Israel on different legislation acts and attempts and stories told. Twitter plays a role, and it is so easy to offer then so many competing interpretations about I don't know how many characters you can use now on Twitter, but it is a very limited number. So it tends to boil down to very simplistic messages that are simply so often and way too often simply instrumentalized to mobilize a specific group of voters for purely domestic political campaigns, and the trade-off and the price we pay is a worsening atmosphere between the nations, and again, this we see how much a zero-sum game it actually is, if not a negative-sum game. So I hope we will continue talking in less formal setting in 1 hour and a half from now. Yes, more or less. So thank you so much for all the speakers and everyone who came, and also for the gentleman who made it possible, the streaming and the recording. And this will also allow other audiences in the weeks and months and years to come to watch this conference and to listen to all the presentations. Thank you so much. The conference is now closed. Thank you.